Good morning, friends. Last 10th, that is 2 weeks back, we had a discussion on data trust score under the DPCSI framework. At that time, some of the participants had requested that a follow-up session is required to explain how the online DTS system could be used by companies. Therefore, we thought we will be having a follow-up session just to explain how the online DTS system can be looked at and used. At the same time, there was one new development during the last 15 days. That was regarding the guideline which has been issued by the European Data Protection Board regarding certification of a system by which data can be transferred out of the GDPR areas. We also, in the meantime, had extended the DTS online facility from the Indian data protection law to the GDPR. Therefore, I am going to discuss today both the aspects, that is the application of DTS online system in the GDPR context, and then the requirement of how to manage the new guidelines which have been issued by the EDPB on data transfers. So that is the objective of today's discussion. So last discussion, we had covered the basic concept of data trust score, which was built on the framework of DPCSI. We had briefly spoken about what is DPCSI, that is Data Protection Compliance Standard of India, and how DTS can be built on the DPCSI framework. So we will continue from there. But before we go further, let us very briefly recollect some of the things which we discussed last time, so that people who had not visited that session may just get themselves refreshed. Now, we know that we are talking of DTS or Data Trust Score system, which is as discussed in the Indian law, which is the proposed data protection law in India, which is in the form of Personal Data Protection Bill 2019. We have heard today that the Minister of IT has told that they are not likely to delay the passage of the bill indefinitely. They will try to pass it within a few months, he has said, which essentially means that it will not happen during the monsoon session, but we have to wait for the next session. However, this data trust score as a concept has been discussed in our law in a manner which is slightly different from what perhaps data science people would be using the term. In the normal, you can say IT terminology, data trust may refer to reliability of data, which basically means that the integrity of data can be managed properly. At the same time, perhaps even you can say unauthorized alteration can be identified, and that brings a kind of trust to the data. But what we are discussing here is the legal terminology used in the Indian law, section 29 on data audits, which says that every organization which is recognized as a significant data fiduciary has to undergo a mandatory annual data audit, and that has to be done by an accredited external auditor, and such an auditor would, after the assessment for audit purpose, also provide a kind of evaluation of the data protection measures which the organization has implemented in the form of a number, which is the data trust score. Now, data trust score may be any number, let us say between 1 to 100, maybe from 1 to 1000. We do not know, or it can even be like the CRISIL ratings, like A plus plus or B plus plus or something like that. Now, we have taken a certain model and built a data trust score. And in this method, we try to evaluate the data trust score as a number between 1 to 100. Now, as per the law, DTS may still be considered optional, but it is likely to be a barometer which any wise organization would not miss to say not state, particularly when two organizations are competing with each other, and one of them, if they come up with a data trust score, there will be a pressure on the other organization also to come up with a data trust score. This concept is unique in India. GDPR has not mandated such a concept, and in GDPR, if you want to look at the compliance, you look at the various measures taken for compliance, and then arrive at a satisfactory compliance or not satisfactory kind of a compliance, more or less like a binary decision. Whereas in India, it is a question of say assessing the level of compliance or a maturity of the compliance across a scale which is continuous over a range of numbers. Now, if you want to understand the concept a little more closely, we can say that any organization which is using data has something called the privacy risk and a data protection risk. Privacy risk is more appropriately a risk associated with the infringement of the privacy rights available to a data principal or a data subject, while the data about the individual is being processed by an organization. On the other hand, data protection risk is a terminology which we need to understand properly. In one sense, you can say data protection risk in association or in the context of privacy is how the data is protected. That is, the personal data which is relevant for privacy risk management is protected. So it can better be called personal data protection risk. If you simply say data protection, we can also apply it to the normal information security scenario, where you try to protect the data from the confidentiality, integrity, and availability perspectives. But as far as our discussions are concerned, we shall not make much difference between privacy risk and data protection risk. So if we say privacy impact assessment, it also is same as data protection impact assessment. So the two are used as the, you can say, interchangeable terminologies. Now, so an organization needs to manage this privacy or data protection risk, for which it takes various risk mitigation measures. Now, because of this risk mitigation measure, a residual risk will be arrived at. This residual risk is total risk, depending upon the context, usage, criticality, etc. Then as modified by the mitigation measures. Now, this residual risk needs to be absorbed by the organization. To some extent, it can be insured, but even if there is an insurance, insurance does not always cover the 100% of the risk. There is always a need for the insurer to bear a part of the risk. So there will be a residual risk, however small it is, and that will have to be absorbed by the organization. This risk may manifest either as a civil penalty risk where there is a financial liability, or there could be a criminal penalty risk. Civil penalty risk can be insured, criminal penalty risk cannot be insured. Criminal penalty risk means a risk in which non-protection of data as envisaged under law could result in a prosecution of the organization and its executives. GDPR does not have criminal penalty risk, but Indian Data Protection Bill will be having a minimal, you can say risk in terms of criminal penalty. At the same time, Indian law is more tightly integrated with the non-personal data protection also. Therefore, certain aspects of Information Technology Act, which may lead to criminal prosecution, will be applicable to the data protection regime in India. In fact, the CERT-in, which is a statutory body created under Information Technology Act, is likely to be a co-regulator in certain aspects along with the Data Protection Authority of India. So criminal penalty risk is very much relevant in India, a little less relevant or perhaps not so much in the case of GDPR. But we must remember that whenever there is a data leakage kind of situation, while GDPR or PDPB will impose civil penalties on the organization which has been non-compliant, there is always a cyber crime legislation, whatever way it is called, cyber Abuse Act, Computer Abuse Act, or something like that, or in India Information Technology Act. It will always be lurking in the background for imposing criminal penalty. Therefore, an organization needs to be alive to the possibility of criminal prosecution on its executives, because most of these laws extend the criminal penalty applicable in an organization to its key executives like the business manager or the CEO. In this context, the concept of DTS is that what is the effectiveness of the mitigation measures? It is a measure of answering this question. What is the effectiveness of the mitigation of measures taken by the organization? Is it commensurate with the risk? Risk assessment is, of course, the starting point. Therefore, is the risk mitigation effort commensurate with the risk? And more importantly, is it in accordance with the compliance requirement? Because if you are compliant with law, then law will protect you. Like penalty will not be applicable, prosecution will not be possible. Whereas if you are not compliant with the law, then even if there is no loss which any data subject has suffered, there can still be a civil penalty imposed for, say, potential data breach, non-compliance of provisions, such as you have just not appointed a data protection officer, there may be a penalty for that, though nobody has suffered a loss. Similarly, criminal penalty risk may also arise even when there is only some non-compliance not leading to any loss to any data subject. So the concept of DTS tries to see whether an organization is implementing its risk mitigation measures in accordance with the compliance requirements as per law. Ultimately, all the risks we talk of converge into this civil penalty and criminal prosecution and the level of compliance. So that is the reason why we are focusing on implementing data protection compliance management system in an organization as different from the ISMS or the Information Security Management System or ISO 27701, which could be a PIMS management system. So we consider ISMS and PIMS as secondary to DPCMS because DPCMS means Data Protection Compliance Management System. So whatever is the law to which we are trying to comply with. Now, if there is a framework behind this management system, ISO 27001 is the framework for ISMS, for evaluation, certification, etc. Similarly, 27701 could be used for evaluation of how good is the PIMS system. Again, these are secondary to the standard which is being used for DPCMS evaluation, which is the DPCSI or Data Protection Compliance Standard of India. This is closely related to DPCMS, just as ISMS and ISO 27001 are closely related, PIMS and 27701 is closely related. So mitigation lies in compliance, and DPCSI is the reference framework which we will be using, and we will be looking at how well the organization is compliant with the data protection law of the relevant land. Now, DPCSI is actually built as to be in conformity with the code of practice, which is stated both in the Indian PDPB as well as in GDPR. Section 50F PDPB 2019 talks about code of practice and the possibility that the Data Protection Authority can approve certain codes of practice. Similarly, Article 40 of GDPR also talks about a possible approval of a code of practice, and if it is approved, then the adherence to that code of practice, that is adherence to an approved code of practice, is considered as compliance to the relevant law. So data trust score measures how well an organization is in compliance with an approved code of practice. Now, we in India, we are expecting that we will be perhaps getting in touch with the Data Protection Authority at the appropriate time to get our DPCSI recognized as a code of practice. As far as GDPR is concerned, we have not so far approached the DPB for certification. In fact, there is very little action in GDPR even in the last 3 years. At least in India, we are talking of this code of practice, a framework for that much before the law is coming into existence. In GDPR scenario, even after 3-4 years, we still do not have a popular kind of code of practice. But now, slowly, at least in France, some effort is being made to bring in a certain code of practice and the supervisory authority to look at it and approve of that. Now, when you say code of practice, we will see how it affects our DTS system. Now, the impact of DTS, if you look at it, which we said could be optional, is something like this. That is, if there is a service X, which is given both by organization A and organization B, then a data fiduciary intending to provide some data for processing to organization A or organization B will be trying to make an assessment of which is the better organization. Similarly, a data principal, if he is reasonably knowledgeable, he will also be looking at organization A and organization B from the perspective of which is the better organization from which he can pick up the service. We can sometimes say that data principals are not that well informed so as to be able to distinguish two organizations from the perspective of data protection. But In India, at least, we are thinking of having an intermediary called the consent manager, who is also a data fiduciary, and he will act as a trusted repository of personal data from the data principal and then deal with the consent with the data fiduciary, or even for exercising the rights of the data principal. In that context, data fiduciary, which is a professional organization, would definitely look at the DTS as a parameter of the organization A or B from the perspective of which is better as far as data protection is concerned. That is, the privacy risk management, if my data is handed over to organization A versus privacy risk management if I hand it over to organization B, which is preferable to me, is some kind of a decision which the data fiduciary will try to take. Same a consent manager, who is also a professional organization specially registered with the Data Protection Authority in the Indian context, will also be asking the same question: which organization is better from the perspective of data protection? So therefore, this DTS 70 and DTS 40, if they are the data trust scores of these two organizations, it will make a significant difference for the data fiduciary or the consent manager to provide the service. Both of them will prefer to work with an organization with a higher DTS rather than an organization with a lower DTS, which in due course, data principles also will recognize that A, B, C, D consent managers are recommending A versus B, and that information will percolate to ordinary data principals. They will also start using the organization with a higher DTS as compared to organization with a lower DTS. This is going to be a kind of impact which DTS is likely to have over a period of time when part of the industry starts using the DTS for its own evaluation and in a way communicating it to its data principles. Now, in the GDPR context, one of the major concerns is, of course, the transfer of data across the border. And for countries like India, which is a predominantly a data processing domain, we need to import data from the EU region and ensure that we don't have any problem arising out of India not being one of the adequate countries as far as the GDPR is concerned. So this cross-border transfer is a concern not only for the data importers in India and also for data exporters in Europe, who may have a good functional relationship with the Indian data processors, but now they are confronted with the legal requirement of answering the question of the supervisory authority, why they chose a particular data processor in India, whether they had made enough evaluations as is required under the law. In this process, we are trying to assist the organization through a kind of certification which we have called as Data Importers Assurance Certification, which will be an extension of the GDPR compliance certification, which automatically comes with the DTS. So today, if Ujjwala Consultants is going to issue a GDPR compliance, it could give GDPR compliance certification, a DTS, and also the Data Importers Assurance Certification. So therefore, we will discuss not only how to use the online DTS tool of Ujjwala, but also the relevance of this Data Importers Assurance Certification. Now, for evaluating the DTS, the steps involved are, first of all, we have to establish the compliance requirements which are required under a reference framework, which may be GDPR in one context, Indian law in another context, CCPA or some other law in another context. So first of all, the frame of reference will have to be determined. This is like scope determination. Scope in terms of which law we have to take into account. Then we have to check the organization's efforts on data protection compliance, item by item, and then try to arrive at where the gaps exist. What are the requirements under law? What has been done? What is the shortfall in that? And based on this evaluation in comparison, we need to assign certain value to the compliance on a certain scale, which we have adopted as 1 to 10, because we have identified about 50 parameters under which the compliance to Indian law or GDPR could be evaluated. So on each of these 50 parameters, we try to evaluate on a scale of 1 to 10. Therefore, there are nearly 500 points to be evaluated as a totality. And we aggregate this assignment of value across all the 50 parameters. Even that we don't simply add up. Actually, our module or say methodology tries to identify 5 different responsibility centers in the organization and distribute these 50 implementation specifications as responsibilities of the management, responsibilities of the DPO, responsibilities of the legal department, then HR department, and then the IT department. And then we also allocate a certain weightage for each of these subtotals of DTS score for each of the responsibility centers. As of now, we are keeping this weightage system as something which will be done by Ujjwala as the auditor. And in the self-DTS evaluation tool, the organization will only calculate this DTS on a straight basis, and then they can even total and keep their evaluation in terms of the total DTS score. But when it is submitted to Ujjwala, what we do is we look at it once again, assign weightages, and try to adjust the data trust score as self-assessed by the organization with these differences arising out of the weightages. And that is what we are trying to provide as a weightage adjusted self-assessment of DTS, which can be done online without any direct involvement of the auditor. To that extent, it makes things easy and definitely much more, you can say, economical. So this methodology requires conducting of a risk assessment to ascertain the risk of non-compliance with reference to the reference frame, which is DPCSI. And then when we make that risk assessment, we try to allocate or identify the risk, then the significance of the risk, then the probability of occurrence. And with that, we come to a residual risk assessment for each implementation specification. Then we will be looking at what mitigation efforts have been taken and the assessment of the residual risk, less or how it has been reduced by the mitigation efforts. That becomes the final residual risk. Now we allocate the numerical value of compliance evaluation or effectiveness to based on this net residual estimation of the risk, and that is considered as the data trust score. Now, theoretically, you can say that if an organization is compliant to all the laws of the land, then it will have a theoretical maximum score of 100. But this is only a theoretical maximum, because legal interpretation of different prospects, different provisions of the Act is not always consistent. Even at the highest level of Supreme Court, we often see decisions about something taken today by one bench, tomorrow the same bench or another bench may have a different viewpoint. So legal interpretations are highly judgmental, and it is not easy to come to a consistent viewpoint. So getting 100 out of 100 as a DTS is considered not theoretically possible. But while you can always debate on whether a score of 75 and 72 are different, how significantly different, etc., you can definitely make a case when you arrive at a DTS score of 70 for one organization and 40 for another organization. Definitely, in that case, you can make out that the two must be substantially different from the point of view of safety of personal data. So we are looking at the evaluation of DTS without worrying too much about the theoretical maximum being achieved, anybody getting 100 out of 100 kind of a thing. We don't want, it is not expected also. But one has to be faithful in making an assessment of the risk and then assigning the significance of the risk, which may depend both on the sensitivity of the risk as well as the volume of risk transaction. And after that, you assign the probability of risk, which may also depend upon the vulnerability status of the organization. And finally, we arrive at the mitigation efforts. And then you can come to the evaluation of the DTS. So DTS is considered more useful in comparing different organizations, and it will determine the competitive superiority of one organization over the other, which is very, very important as far as the business is concerned. Now, this framework which we are using, DPCSI, is founded on 12 standard principles and 50 implementation specifications. The implementation specifications will be interpreted based on the applicable law, like GDPR, there will be an interpretation, and the PDPB, there will be a separate interpretation. Like what should be the privacy notice in respect of GDPR, that privacy notice will be perhaps slightly different from the privacy notice expected out of the Indian law or CCPA or something like that. So DTS as a concept can be used both for Data Protection Act of India as well as GDPR as well as any other law. We are trying to use it for today, demonstrating how it can be used for the kind of say the GDPR context. Okay. Now, as I already mentioned, for calculating the DTS, compliance is evaluated against 50 model implementation specifications. For each of these implementation, score is placed between 1 to 10, and then they are aggregated over 5 different responsibility centers. Different weightages are applied to different responsibility group, and then we arrive at the total, which will be the total DTS. Now, if you look at applying this to the GDPR compliance, we must remember that GDPR compliance essence runs around understanding the compliance role of the organization, like whether it's a data controller, data processor, whether it's a joint data controller, or is it's only a recipient of data, and so on. And also, in terms of the applicability, it may determine whether the role of the organization is that of a organization which is established in the union, or whether it is an organization which is not in the union but trying to make a business with EU customers, or doing a profiling of EU citizens or residents. So these are the things which are required for establishing the scope of the organization. Then the organization needs to have an understanding of the principles of establishing the lawful basis for processing, and then understanding the data subject risk. These are the background information which an organization needs to know for compliance. Then chapter 4 of the GDPR talks about general aspects of compliance, and chapter 5 talks about the cross-border transfer requirement. So these two chapters become very important as far as the compliance is concerned. In fact, if you take chapter 4, which is more or less the complete codification of the compliance, we have tried to look at each article and then try to map it to the model implementation specification in the DPCSI, and it appears that all the articles are adequately represented by different model implementation specifications. In fact, the MIS of 50 implementation specifications goes much beyond the requirements of GDPR. It will have many other implementation suggestions which will enhance the compliance of GDPR. So one can be confident that if you are adopting this as a frame of reference, you will be quite, safe, even when you compare the alternatives, which is the 27701 ISO, which has to be implemented along with ISO 27001 for certification purpose. Compared to that, maybe DPCSI is going much beyond and provide a better framework. Now, coming to this online DTS system, why have we introduced this online DTS system? We feel that there are a number of organizations, particularly the MSMEs, who have their own issues in terms of being GDPR compliant by inviting a big four, say, data auditor or something like that. So most of these MSMEs are concerned with the cost, accessibility to a quality auditor, and therefore they remain either non-compliant, waiting for being led into a situation where they are forced by a customer who asks a specific question, are you GDPR compliant? Then only they will start running around. At that time, if they are in a hurry to get a compliance certification, they are likely to be victims of some kind of a very diluted form of assessment. So we felt that there is a need to provide an option to these MSMEs to have a modular approach in the in achieving the compliance with a very low cost to start with. And when they start understanding what this compliance means, then they can go to higher levels. So for this purpose, what we have done is we have created a compliance questionnaire, which is available on a website, ujjwala.com. And actually, we have created 5 different questionnaires, one for each responsibility groups, like this management, BPO, IT, then legal or HR. And we are also suggest that if possible, different persons in the organization can try to fill up these questionnaires. And access to this is given at a very nominal fee. In fact, approximately there are about 289 questions to be answered by an organization in the GDPR context. So it covers fairly what all are required for compliance. In fact, when we say a question, when an organization completes the questionnaire, what it will take as the understanding is, one, these are the things which I am supposed to do. They can check whether they have done it or not. Then even when we talk of a specific policy document, the questions will ask, does your policy include this? Does your policy include this? And so on. That actually gives an opportunity for the organization to jot down that, yes, I need this policy, and this policy need to have these items. So therefore, when they complete the questionnaire, if they are properly attentive to the elements of the questions, they will be able to understand what is the requirement of compliance, and without our giving any kind of template, they can self-develop the template. We don't believe too much in this template being given straight away, because it makes the data protection officer or the organization not think as deeply as they should do. They will just go on trying to fill up the documents. Whereas when we ask the question and leave it to the organization to answer it in the form of a document, policy document, they are likely to come up with a better template for their own purpose. So we are trying to leave it as questions, and we want the organizations to understand through the questions what are the requirements and use their own templates. Of course, if there is a consultant who is assisting them in this process of implementation, at that time the consultant will perhaps provide his own template, and then the organization can work around that. Now, when an organization completes this questionnaire, for which sufficient time will be provided, you can actually stop and restart at any point of time. You can take maybe you can stop today, and again tomorrow you can restart, kind of a thing. And within the organizations, you can have 2 or 3 people group together and then try to go through the questions and then formulate their answers. So at the end of this exercise, they will be able to take answer these questions, and every question will have 2 supplementary questions. One will say, based on your assessment, what is the data trust score you would assign for this implementation specification in your organization? We expect that you know the risk, you know the mitigation efforts which you have taken. Therefore, you can say my DTS for this particular aspect is 4, 5, 6, 7, or whatever is that. So that is one question, which is the self-assessment. Secondly, we ask you to actually put in the list of documents which you have referred to in arriving at this DTS. So there is a commitment as far as the organization is concerned about the evidentiary documents which they have seen, which is also entered in one of the questions. Therefore, at the end of the exercise, you would have answered the questions, you would have listed the evidentiary documents, and based on that, you have arrived at the DTS, and that is how you are able to arrive at the self-assessment of the DTS, which when you hit the submit button will come to us, and then we will be making a cursory review of the submission. We will not go into documentation. We don't even collect the documentation at this point of time. But what we will try to do is to assign the weightages for different groups of your answers and arrive at the weightage adjusted self-assessment DTS and give it back to you with some brief comments, which we call as the basic review. We'll give a feedback. Now, with this feedback and the weightage adjusted self-assessment, you can say that you have done your self-assessment, which is adjusted for the weightages as prescribed by the system. Now, that is one stage. Now, beyond this, you can also try to implement certain improvements to various provisions. And then when you have improved, you may try to resubmit the documents and ask us for a second review or a third review, because this is an iterative process. You can go on, and we will be, of course, charging a fees for documentation review. But over a period of time, you know that whatever implementation you have done has been summarily assessed by another consultant. So you will be reasonably confident that your self-assessment is not just out of blue. Somebody has tried to review it. That will be the summary assessment of the DTS based on the document submitted by you, either once or multiple times. Then at the next level, after the subsequent second or third review, if you feel, or if the organization feels that they need a full-scale audit, they can always ask for DPCSI auditor to audit the organization by physical, say, interviews and inspection. Then they can arrive at a certifiable, you can say, assessment of the compliance and therefore the audit. So this is the final outcome of a certified DTS. Today, organizations have to directly call an auditor for this kind of an audit. Therefore, the auditor provides a certain code where he takes into account all the imponderables and then his cost and effort, time, etc. And that becomes sometimes a little higher as far as the expectations of the auditee organization is concerned. Whereas in this system, we have provided a modular approach, a self-assessment at a very nominal rate, a summary assessment, also at not too much of a cost, and then review of the summary assessment at very reasonable, you can say, modular cost, and then finally going in for actual audit. This actually spreads out the cost and the effort depending upon the organization's requirement. In fact, today, if you do not have a client, but you just want to be ready for DTS, compliance, then perhaps self-assessment and a summary assessment would be more than sufficient. But tomorrow, if you really want a full-scale audit because some organization is asking for that from your vendor side, then you can quickly go into the audit mode. Since you already have a self-assessment, you already have documentation, you have already got this documentation reviewed, maybe the time factor required in full-scale audit will be very much compressed. This is the objective of this kind of modular implementation of DTS evaluation. Now, with this as a background, if you actually want to make use of this particular scheme, you should go to www.ujjwala.com. If you go to that website, you will be having the links, My DTS, which is for the Indian Data Protection Law. Another link is there for DTS GDPR. Tomorrow we may add more such links like DTS CCPA, DTS Singapore law, etc. But right now, GDPR is a fairly good framework based on which you can ensure that the documentation is done for compliance with other laws also, and we can ensure that the same framework is used for compliance with other data protection laws also. We will actually go to this particular link and then look at a few questions just to give you the understanding of how it works. But before we go into that, I would like to very quickly go through this concept of data importers assurance certification so that you will understand its importance before we go into the actual demo of the tool, which is not a very sophisticated tool at this point of time, but I think it is reasonably sufficient for the use of any organization. Now, as far as the data importer certification is concerned, why we are talking of a separate certification called data importer assurance certification is that very recently, as 14th June, the EDPB has come up with a document for public consultation, which is called the Guidelines for Certification. Now, what they want to do is that in any case where the data importer's country is not coming under the Article 45, this is the adequacy rule, then the controller has to work out alternate methods for getting the assurance that personal data of EU citizens which goes out is handled in a manner in which it is compliant with the GDPR. For that purpose, under Article 46, various alternatives may be provided, and this certification is expected to check on the level of compliance of these alternative methods used for the purpose of GDPR compliance. Now, one of the instruments used for this particular purpose is, of course, the contract. All contracts should be binding and enforceable instrument. You can call it as a binding corporate rule or a standard contractual clause, or even a, let us say, data processing contract. But any kind of instrument, it has to be an enforceable instrument, and it should be binding. Now, EDPB has come up with a certain code of conduct for this particular purpose, which can be followed by the data exporter and the data importer all together. And they have also come up with a method by which they can approve certification agencies, and then certified bodies will actually examine the contract and other arrangements and try to come up with a kind of an assurance. Now, this is yet to be fully implemented even in the European community, but we have actually done something much in advance of everybody else in the world by creating this data importers assurance certification. But we are not at this point of time an organization which can be called approved under a supervisory authority, because that requires certain formalities which we will do after the particular guideline is say finalized with the public comments and so on. Or we may for some time not bother about it, because we will only focus on preparing the Indian market for compliance. And the Indian data importer can always share his certification of assurance with the data exporter, and let the data exporter approach the supervisory authority and get the concurrence as far as the transfer to India as a non-adequacy country is concerned. So without going too much into that aspect of are we an approved certification agency for GDPR, let us just look at what we intend to do for the compliance. Now, this particular guideline has 4 parts. The first part is basically a kind of a general description of the scope of this particular guideline. Then there is implementing guidance on accreditation requirements for the certification body, and then the certification criteria. Then what is more relevant for data exporters or importer is part 4, which is binding and enforceable commitments which are to be implemented. Now, it is envisaged that the data importer, who is actually a person beyond the shores of EU, to be granted a certification, or the data exporter who will himself try to obtain this certification on behalf of the data importer. We have to see whether data exporters will take the lead here, but what we are suggesting is for the Indian community to start their own exercise, and let us first start with what we can do and challenge the data exporters that this is what we are doing. Please try to get this approved by your supervisory authority. That will make their work also easy. Now, what are the specific aspects which are required to be fulfilled here? One is, of course, all this runs around the contract under which the controller will transfer the data to the processor, and the instruments should be able to demonstrate that there is a binding and enforceable character to the instrument, and the exporter and the importer will have to ensure that certain key you can say provisions are incorporated into this agreement. For example, one of the things which data importer has to warrant is that the data importer has no reason to believe that the laws and practices in his country applicable to this processing, including requirement to disclose personal data to any law enforcement authority or a public authority like the government, does not in any way affect the GDPR regulations. So this is a warranty he has to give. I will not let my government to come and ask my ask this information. But you know that this kind of an assurance can only be given on paper, but it is unenforceable because every sovereign country will have the powers under the hands of the government. Appropriate due process would be there, but powers will still be there with the government or a law enforcement authority. And in case of requirements such as a crime or something like that, they can demand information, which may include the personal information which is being processed on behalf of a EU data controller. At that time, the data importer of this country will not be in a position to refuse handing over the data. So this kind of commitment or warranty is something which is difficult for the Indian data importers to provide. The second important warranty or provision which has to be included here is that the data subjects who are actually citizens of the EU or residing there should be having a right to enforce their rights under their contract with the data exporter against the data importer in another country. One, the data importer does not know who is this data subject because the contract of consent is between the data exporter and this data subject. And from the data exporter, the information has come to the data importer who has done some processing. And suddenly one day he may receive an email from somebody, I am the data subject, Mr. So-and-so, you are the processor for my data controller, and I want to enforce certain legal liability on you. And this particular agreement also says that this enforceability should be possible in the courts of the data subject usual place of residence or habitual residence, which means that if a person is in some district in, let us say, France, he may go to the local court, and this data importer of India has to run to that court to answer this person because he has agreed for that in the contract. This is the expectation which is there as far as this data transfer is concerned, which is also something which is, in my opinion, legally infeasible. It is actually not acceptable to the international jurisdiction. No courts in India will agree that their interference is not required. Directly, you can go to a foreign court. Normally, one has to prove a particular offense in a court of the country in which the offense has taken place, and then you try to transfer it to the court in another country or vice versa. So this is again a difficult commitment to give in the contract, but most of the time the parties are bound by business interests, and without looking at the consequences, they may simply sign the contract. And we, as somebody who is interested in the general welfare of the data protection community, which includes the individual professionals as well as the organization, we are interested in ensuring that no Indian data processor blindly signs contract and creates liabilities which he is unable to fulfill because Indian law does not permit it. And for having agreed to do something which is not provided in the law, he is actually committing a breach of trust or cheating the data exporter. And he may be tomorrow called on to explain that criminal consequences of data breach in entering into the contract. So to prevent that only, we are trying to have some acceptable means by which compliance has to be worked out. And that is why this data importer assurance certification is being looked at. Now, having explained the near impossibility of these clauses, you may ask me then how is it that we are able to give a certification? But what we are saying is that we have tried to develop a certain methodology for processing of personal data. And if that process is scrupulously followed, then we will be able to provide this certification. So it is conditional to the use of a certain technology process, which we may say that without that it will be difficult to provide the certification, or we will qualify the certification if it is not entirely to our satisfaction. But we are reasonably confident today that if you actually follow this particular process, maybe we will be able to give you the certification, and that will also be acceptable to your data exporter. It is in this context that we are saying that our DTS GDPR full audit will lead to certification of GDPR compliance, representation of DTS, and the data importers assurance certification. Because this guideline says that this certification for the purpose of data transfer cannot be issued without a general compliance to GDPR. So just like ISO 27701 cannot be complied with unless you are compliant with 27001, this data importer assurance certification will not be available unless you also opt for GDPR compliance, and unless the two are there, it has got no value. So with this general information on both the DTS online system as well as the data assurance system, data importer assurance system. We will now go and explore these specific links. After that, if any questions are there, we will try to answer that. For this purpose, I will try to close this presentation and then share the screen for the website. Okay. Now, if you go to this ujjwala.com website, you will be having these links, My DTS and DTS GDPR. This first page explains the whole concept of what you need to do. And in the case of the Indian DTS, we have given separate links for each of these things. And in GDPR, these links are all already available here. So there are 5 different questionnaires. One for management related issues, another DPO related issues, then legal, HR, and the IT. There are totally 50 implementation specifications. 1 to 15 is the management, 16 to 24 is DPO, 25 and 26 is legal, 27 to 30 is HR, and 31 to 50, 20 implementation specifications cover the IT responsibilities. More or less, the 20 cover all the requirements of ISO 27001 as applied to the personal data coming under the scope of the particular compliance, which is the GDPR. That is, the EU data which is having the GDPR stake, how you protect the confidentiality, integrity, and availability technically will be covered by these implementation specification. Now, for the sake of just understanding how you use that, we will go to the respective link and then see how we will be able to answer that. Now, this particular questionnaires, you can start completing it, and then if you are not through with it completely, you can stop and you can restart. That's why you have got start and resume. If you go to, let us say, something which you have not earlier attempted, you will be asked to fill up an email address, and after that you will be asked to have your own passwords for second access to the same system. It can be anything which use set for accessing this system. Then you come to a request for password which is given by us. This password will be given after you make the initial payment, and that payment will be link will be available here. For example, in this there is a payment link. You can use this payment link and then make the payment, and then the request will come to us. We will be giving you the link as well as the particular password. So whatever password has been given to you, if you put that, then you will be having access to the questionnaire. There will be initial instructions. There will be a certain time allocated for this. The time can be extended on request. That is not a big issue. So the instructions of how the thing has to be filled up is available. Then you will be getting into the questions. So the very first question, of course, will be the organization. Since there was some concern that if you give the name of the organization here and later on talk about your compliance status, there is a confidentiality issue. What we have now suggested is that when you make the payment and make a request for access, at that time, you have to give all this information, like the name of the organization, address, website, contact person, email, and some basic information about the activity of the organization, etc. All these will have to be given to us at the time of payment. Or if you have not given, we will ask for this information. Once you give this information, we will be giving you a kind of a pseudonymous ID, which alone can be entered here on this online platform. Therefore, you don't have to be worried about the data. Suppose you say, I have a policy or I don't have a policy. It is not associated with the name of the company. Therefore, that is reasonably confident. Of course, in the identification, you would have given the email address of the person who is entering it. Probably you can use whatever anonymous email you would like to use there. Now then, if you go into the questionnaire, there will be questions like this. For example, this question is, does the organization have a specific employee privacy policy? Yes or no? Now, what you have to take out from here is that there has to, at least we are expecting that there should be an employee specific privacy policy. Obviously, this is different from other policies. So when you look at this question, you have to take from out of it what is the indication. Now, if you say that there is an employee privacy policy, we will say, does it cover the entire HR life cycle from application for the job to termination? Now, if your current privacy policy for HR does not have this, then it is an indication that perhaps this is what you need to do. So there is a deliverable which is included in this whole questionnaire, which you have to take out from each of the questions. Now, does the policy cover pre-recruitment background verification, onboarding, medical test, etc.? So these are the things which you are supposed to have. Does the policy address termination and post-termination period? Like this, it goes on. Does the policy address employment issues related to training, new projects, travel, and so on? Now, does the policy address collection of information about family for welfare schemes? Now, these 7 or 8 questions for each implementation specification to some extent give you an idea of what kind of policies you should have and what should be the content of that policy. Now, after that, then you are asked to give a self evaluation of a DTS for this particular implementation specification. Okay, for example, here MIS 27. For that, you need to make an assessment. You can give some descriptive comments if you want for the reviewer to decide. Then you can also note here what are the documents which you are referring to here. For example, here you can say employee privacy policy version so and so, or whatever is that. If you don't have, you are not having that policy. At least now you know that there is a gap. So you don't have a policy. Therefore, none of these questions are in the affirmative. Therefore, DTS will have to be low. It can be 1 or it can be 0 kind of a thing. That is your own self-evaluation. This is how question by question it will go through. Certain things which you need some clarifications. Basically, when we give a review, we will tell you what it means. Okay. And maybe you can also ask us if you don't understand a particular aspect, because we have actually conducted certification programs for consultants and auditors under the DPCSI program. So those who have undergone these training programs, which are even available now, you can take this tomorrow if you want as an online training. Those who have gone through this training, they know what we mean by this particular question. For example, if I said here, distributed responsibility requirement, you will know what it is meant in this particular framework if you have gone through the training, or if you are using any DPCSI consultant to assist you in the implementation. Otherwise, in the self-assessment, if you think that there is no distributed responsibility requirement, you answer no and go ahead. There is a possibility that at the end of it, your DTS score will come low. Then when we review it, we will give you where your DTS could be improved. Maybe after that, you will try to look at those areas and try to improve the DTS by adding more policies. And then if you want, you can submit it again to us for summary assessment. So that process can continue. This is how we are going to make you use this online certification, the DTS evaluation system. I hope this will be good enough for you to actually start looking at this. And as I have told you, the cost of this is not very prohibitive. So you can always look at making use of the online DTS system, and probably you will find that it will be useful for your organization. So if there are any questions, we will be happy to answer that. There are a few questions from the chat box. Basically, the questions which I have already explained. So if you have more questions, you please send it to me by email. We will be happy to provide you the details. So at the end of the whole process, we want this system to be useful to you, and probably this should help a lot of organizations to actually get into this compliance mode on a voluntary basis. And in a way, we can try to create a compliance culture in the organization, in the entire country. That is the objective of introducing this particular system. So thank you, friends. For those of you who did not attend the live program, I took the effort to create this as a recorded program. I hope you will appreciate the efforts and make use of the system. You can always contact me over any of the emails on which I am available. We will give you more details. And if you straight away want to go to GDPR compliance or something like that, full audit, you are welcome to ask for information. We will perhaps make a preliminary scope assessment and then give you a quote. There are associate consultants who will be working with Ujjwala Consultants. Of course, in the initial days, I will be closely involved with every assessment. But as we go along, we have a number of people who have been certified for DPCSI consultancy and audit. So they will be assigned to each organization. We will try to ensure that you will remain compliant to GDPR through this process. And at the same time, if you want to be compliant with the Indian proposed law, we are ready with that system. You can start working on that today, at least on a self-assessment basis. So if after a couple of months, suddenly the government comes up with the new legislation and makes it effective on a particular day, you will be ahead of the curve as far as the competition is concerned. And maybe you will be one of the first few persons who will be saying, I have a compliance, I have a DTS. So it helps in marketing your services to the data principles better than your competitors. Thank you.